everyone. So during the conference, we have heard that children need enhanced protection because of their vulnerability. And in my presentation today, I would like to briefly summarize how child-friendly justice is implemented in several Central European countries, and how children's rights to participate appears in different types of proceedings. Before starting, I would like to emphasize that due to the time limit, I cannot address every aspect of today's topic. Instead, I will highlight selected points that are illustrative or raise some interesting questions. Since national constitutional frame are domestic legislation, it is really important to ask whether they guarantee children's rights to participate. Most constitutions in the region do not contain detailed provisions specifically for minors. They usually rely on general human rights clauses or other legislation. However, Slovenia is a notable exception, offering a strong and explicit constitutional protection for children. In practice, children, just like adults, may become involved in the justice system in many ways. So let me briefly walk through the most relevant fields, civil and criminal proceedings. So, as we all know, in our countries examined, anyone under 18 is considered as a minor. Minors generally have only limited legal capacity, most often from the age of 14. However, there are variations. For example, Poland applies this from the age of 13, while Slovenia from the age of 15. In exceptional cases, minors may obtain full legal capacity earlier, typically through marriage at the age at usually 16 with the court's approval. This is possible in Hungary, Slovenia, Slovakia, Croatia, Serbia, and Romania as well. And moreover, in Slovenia and Serbia, becoming a parent also triggers full legal capacity. Because minors lack full legal capacity, they are usually represented by a statutory representative, typically a parent or a guardian. Several countries include special rules. For example, Hungarian law grants children over 14 full legal capacity in lawsuits concerning their personal status. Slovenian, Slovakian, Czech, and Romanian rules contain further provisions regarding adoption or healthcare-related cases. Where the interest of the parent and the child is in conflict, parents cannot act as representative, thus a guardian must be appointed. The terminology varies across countries, such as ad hoc guardian, conflict guardian, ad litem guardian, or even ad hoc administrator. And although minors have limited legal capacity, this does not affect their right to express their opinions and their views. So court must give children an opportunity to be heard and must consider their opinion in light of their age and maturity. Different countries use a presumption to guide this matter. In the Czech Republic, children aged 12 and over are presumed capable of receiving information and expressing views, while Serbia uses 10 as this relevant age. And the methods for hearing children also vary. Many countries allow written, electronic, video-based, or even nonverbal communication, like drawing, playing, body language, and etc. Moreover, Slovenia, for instance, provides opportunities through social centers, children's rights representative, or informal judicial conversations. And moving on to witness testimonies, Hungarian law does not specify an upper age limit for witness testimony, which means that minors under the age of 14 may also be heard in civil proceedings. And in this case, they do not need to be informed of the legal consequences of giving false testimony, but they must be instructed to only tell the truth, and they are also not required to take an oath. In Slovakia, it is also possible to hear minor witnesses outside the courtroom or even outside the court building. And some words of the method of hearing. Minors must be heard in an appropriate atmosphere, taking into account their age, maturity, of course, in a child-friendly manner. In Hungary, minors are heard by a judge, but before the hearing, parties may submit questions to the judge. Hungarian courts have child-friendly hearing rooms, and children under the age of 10 are generally heard there, while children are older are heard in the usual courtrooms. The court may hear the minor with the involvement of an expert. However, in Croatia, children under the age of 14 express their opinions through an expert, a guardian, or a psychologist. And in Poland, special attention is paid to ensuring that the interviewer's attire is informal. For example, the judge may not wear a robe. Oh, is it not working? Okay, so moving on to the administrative proceedings. It is worth briefly noting that these civil law principles influence administrative matters as well. But due to the time limits, I do not wish to discuss it in a deeper way. However, it can be concluded that in general, the regulations of children participation in administrative proceedings is typically based primarily on the norms of civil law procedures. Yes, and moving on to criminal proceedings, children typically participate in these proceedings as victims, witnesses, or the perpetrators of the crimes. And the aim of the proceeding is to protect the interest of the child with particular regard to ensuring that they do not become secondary victims during these proceedings. Most countries require that proceedings involving children be conducted without delay and where it is possible without repetition. And it is also very important that minor witnesses or victims do not have to meet unnecessarily with other persons involved in the criminal proceedings. It is also important to ensure that witnesses are only heard once with the possibility of repeating witness statements in special cases. In Hungary, confrontation of witnesses or victims under the age of 18 can only be ordered with their consent. And in the cases minors under the age of 14, Hungarian law expressly prohibits confrontation. But in contrast, Romanian rules only impose the restriction that the prosecutor's office must summon the parents or guardian to the confrontation of the minor. And under the French law, confrontation of minors may take place in the presence of a psychologist and the member of the minor's family. And Hungarian law applies even stricter rules in cases where a crime against sexual freedom has been committed against a person under the age of 18, because in such cases, the presence of the defendant and his or her defense attorney is strictly prohibited. Slovenian law also contains the restrictions because in such cases the minor victim must have a defense attorney throughout the whole proceedings. Croatian law is also stricter in cases where crime against sexual freedom or human trafficking has been committed, because in these cases the child is entitled to additional rights, such as the right to a counselor, to be interviewed by a person of the same sex, and to refuse to answer questions about their private life. And some special hearing options. In some cases in Hungary, children are interviewed at the so-called Barnahus, which is an informal room where a psychologist or a counselor talks to the child, and members of the authorities can follow the proceedings from a different observation room. It is also worth mentioning that 2 special rooms have been set up for interviewing or hearing minors in 2 large cities in Romania, and in 2016 a room for interviewing minors was opened at the Bucharest Public Prosecutor Office as well. And also in France, many police stations have a Melanie room, which is like a children's room with lots of toys, creating a sense of security and allowing minors to show what happened to them, for example, using dolls. And moving on to the perpetrator of the crime. Yes, this slide, thank you. In the Czech Republic, children under the age of 15 cannot be punished, while in Croatia, Serbia, Slovakia, and Slovenia, minors under the age of 14 cannot be held criminally responsible. In Slovenia, persons between the ages of 14 and 16 are considered younger juveniles, while those between the ages 16 and 18 are considered as older juveniles. And for example, the Slovenian, Croatian, and Romanian criminal codes also treat young adults between the ages of 18 and 21 differently. And we can say that the French law shows the most striking difference in determining the lower age limit for criminal responsibility. It is possible to hold them responsible from the age of 13, and they may even be sentenced at the age of 13 at imprisonment and fines. And from the age of 16, they may receive the same punishment as adults. And also it is worth noting that in the Czech Republic, persons involved in proceedings concerning minors must undergo a special training on the treatment of minors. And criminal cases involving juveniles are heard before juvenile courts, which are not separate judicial bodies. And in Serbia and Romania, there are no specific juvenile courts, but in many court proceedings, the law requires judges to be specialized. Thank you. And enforcement of children's rights is more of a process than a completed stage of legal development. Although the international standards, above all the UN Convention on the Rights of the Child, provide a solid foundation, but actual enforcement depends on the constitutional system, the legislation, and the institutional practices of the country in question. And the examples of the countries examined also show that the creation of the child-friendly justice system cannot be achieved solely by establishing legal norms. Institutional sensitivity, appropriate training of professionals, and the provision of tools to facilitate communication and information sharing with children are also so essential. And thank you for your kind attention.